These are the arguments I'm going to listen to. Now I think it should have been a week-long trial.
Emergency custody showdown. Allegations of alcohol, marijuana, violence, and a 4-year-old at the center. Ryan Wyndham faces explosive claims, but where's the proof? This hearing could instantly change parental rights. Is this real danger or courtroom strategy? Subscribe for more dramatic breakdowns and real courtroom truth.
So Scott Warren versus Idio Warren. Ms. Locke appears with Mr. Warren, and Mr. Olson appears with Idio Warren. We're scheduled for trial, custody, trial. Counsel, I know I saw pre-trial conference questionnaires filed by each side, and then January 7th, I had an order. And that's what I thought this hearing was for, to make sure that there was an order on file and that I had signed it. Apparently what got slipped in here too, I had heard wind that over the holidays there was a disruption in parenting time with Ms. Warren denying parenting time or terminating parenting time. I've now seen at least the explanation from Mr. Warren. I now have documents from Mr. Olson. Counsel, I'm really not inclined in a Zoom hearing today to litigate this whole Christmas fiasco. I think what I had suggested is that if Mr. Warren perceived an absolute violation, that there should be a contempt citation filed. And today's not a contempt hearing, it's a motion for attorney's fees and an admonishment. And I'm probably going to do that at the trial, but I just want to get this case ready for a custody trial and make a final decision after hearing evidence on what the custody situation is going to look like, honestly. And I will tell you, because of these parties, and I believe there's this kind of situation is going to be ongoing. If we continue with all the alcohol monitoring requirements. I am of a mind that this needs to be a situation where there is an ongoing scram device or interlock device or nothing. And that I thought this was a great plan to begin with. And now I got these parents arguing over the fine tuning of what is, a fairly complex plan that I've never had before in any cases and to this degree. And for me to constantly be monitoring it and having hearings on it, I just think that it just further lends itself to issues with these parties that are highly conflicted parties with custody of this one child. And so I think I need to decide whether he needs something full-time for a year or two or a month or two or nothing at all. But I don't think this plan that was laid out with Miss Langworthy is workable between these two, where it allows someone to unilaterally terminate visits. It's just not going to work. And since Mr. Olson, your client's asking me to give her primary residential custody, then I think the agreement that they had with the domestic conciliation is out the window too. I mean, it's all or nothing. And if you're asking for change of custody, and I believe that I need to grant a full evidentiary hearing with counsel, so that I can really nail this case down and limit motions in the future based on material change of circumstances, then I think everything's fair game. You know, Miss Langworthy is probably the best domestic conciliator that I've had, honestly. And I haven't had her in very many cases. And this was probably one of the most specific, intensive, thoughtful plans. It required a high level of compliance. And I definitely think it should have been complied with in the short term. I just don't think that this is a plan that should be expected, that it be indefinite and that it continue to cause consternation between the two parties in terms of compliance. So that's kind of my thinking, just so you know where I'm coming from. If you think we need a hearing today on something, fine. Or if you want to use it as evidence in terms of arguing custody, you can do that as well. I mean, one of the factors is ability to co-parent. And so I don't know. So Ms. Locke, what was your intention that we would accomplish today?
Your Honor, I sent a pretty extensive email to Mr. Olson yesterday attempting to resolve the hearing, and he indicated that he still wanted to have the hearing today. I didn't intend to be heard on the motion to enforce the parenting plan today because the child came back to my client. At some point, obviously, those things will be addressed and those factual circumstances will be addressed. They were added to the pretrial order, so those issues are preserved for trial.
Okay.
If Mr. Olson wants to have argument today on his allegations of the missed test, I'm prepared to proceed on that. But I would agree with the court that these are all evidentiary things that can be dealt with at the trial that's already been set on the case.
All right, Mr. Olson, your thoughts.
I understand that, Your Honor. And obviously being appreciative of the fact that it's Friday afternoon, we're about a month out from trial. I thought it was important today to at least check in with the court.
Okay.
I completely understand and actually appreciate the court's feedback on I did not file a contempt. I'll discuss with my client doing that to possibly have that addressed at the time of trial. But again, I appreciate the court's thought as well that, with us asking for a universal change in the parenting schedule and with, residency and custody, that anyway, that may not be as much of an issue we want to address through a contempt. More than anything, Your Honor, again, to check in, I know we've got the pretrial conference order filed. There have been, I'm fine with not litigating the issues that have come up over the last since October 27th, because that was the last time we were with the court. The missed tests that have come up since October 27th, as obviously we will have the opportunity over our 2 days evidentiary hearing setting to litigate those. I guess maybe more than anything, if we can get a little bit of feedback or guidance from the court to try to prevent issues from coming up between now until we get to trial, the court's order from that October 27th hearing adopts Ms. Langworthy's most recent recommendation and those provisions within the recommendation that the court's alluded to that discuss the alcohol monitoring. I would point out Ms. Langworthy's recommendation says that if there's a failed test, like a positive test for alcohol failed, then believe it says that the parenting time shall be forfeited. I can't speak. Mr. Warren will not have parenting time until his next scheduled parenting time. But I believe it also indicates that if there's a missed test, or the testing's not done on time, or there's missed tests during the parenting time, that Mr. Warren has, that his parenting time can be forfeited to the next time. I only reference that is because the court's order from October 27th said that it adopted the recommendation, but then the court took the additional step to say that if, and I'm going to get the paragraph for you, Your Honor.
Now the focus shifts to the police reports, and things get technical: redactions, foundation objections, hearsay concerns. If evidence isn't properly authenticated, it collapses fast. Emergency custody demands clear, admissible proof. When documents look suspicious or incomplete, judges hesitate, and hesitation here favors maintaining the current parenting arrangement.
Paragraph 6 talks about the alcohol monitoring. If there's a positive test or violation of the recommendation's alcohol requirements between October 27th and the time of trial, petitioner's parenting time will be immediately suspended until the time of trial. So I guess a feedback on if there's an issue with a missed test moving forward would be what the steps would be for my client. Obviously, I think it's pretty well stated if there's a positive test for alcohol that the time would be suspended until we get to court. But that's I guess the issue, because there were, and we provided it as an exhibit, Your Honor, there's been 2 missed tests during the parenting time, and then this issue on December 28th where there was the parenting exchange was to happen at 6 p.m. About an hour before that, Mr. Warren communicated with my client that he was coming back from Manhattan, and that his parents were going to be there at the exchange, but there was not a test done through the SoberLink device that the court has required. That testing wasn't done, I think, until 10 o'clock that day. So either way, if we can have some feedback, if there is any the court's got, I don't think it's probably useful to litigate this afternoon when we have about 4 weeks until trial, and we will obviously have the opportunity to address it at that point.
Your Honor.
Yes.
I want to get a little bit more context if possible. So Mr. Olson presented these exhibits to the court, and one of the exhibits is some Our Family Wizard messages between the parties on December 23rd. And in those messages, Ms. Warren says, no videos were received on the evenings of November 4th or December 9th. November 4th was not my client's parenting time, so that was either a typo or just an error on her part. And December 9th is one that Mr. Olson has continued to address. But then she says, please notify me if a video will be missed so that I am aware and do not worry. And that's exactly what my client did on December 28th when he didn't have his SoberLink, and he said, hey, I'm going to not test. I'm going to send you this alternative test, a blow in the car with the handheld device that shows 0. And so while I appreciate her position that like there's been these alleged like missed tests, she didn't do anything about them at the time. She told him what the alternative would be, which is notify me if you think you're going to miss so that I don't worry. He does that very thing, and then she says you can't have your kid for the rest of Christmas break. So I agree with Mr. Olson that we need some clarification, but I disagree with this idea that Mr. Warren has like just been violating this order and completely non-compliant and isn't doing what he's asked, because I think the parties have worked with each other and tried to work through these things until the guillotine is dropped on his parenting time.
Well, I know, but nobody gave them the authority to modify or approve anything.
Agreed.
Right? That's part of the
Agreed.
problem is, well, she said it was okay yesterday, but it's not okay today. Well, again, these people are so highly conflicted. I think the rules are the rules, and they don't have the authority to modify them unless they come back to court or it comes through their attorneys in a written order that you can give to me. And so that's how I kind of feel about that. I guess my question, Ms. Locke, for you is, can your client not comply with these provisions between now and the time of trial?
He 100% can, Judge.
Okay.
He's been blowing in a device of some variety or doing some sort of testing since August of 2023.
Good. So it says what it says. And so I guess your client knows that if he fails or misses the test during his parenting time, he is not going to get visitation till after the trial. Because I'm probably not going to have time to hold a hearing and have a full evidentiary hearing.
It also says that she is required to pay for half, which she has not done. It also says that she has to get a mental health evaluation, which to date we have seen nothing regarding that. So I appreciate the court's position that he gets these very harsh consequences.
And again, I need you to file a contempt. Or this is what you can argue at the time of trial to say, hey, judge, he shouldn't be having to do any of this anymore. She's not fulfilling. It's obviously not important to her enough that she's paying her half. Judge, she wants primary residential custody, but she won't bother to get a mental health assessment. I mean, these are the arguments I'm going to listen to. Now I think it should have been a week-long trial, but it's what I'm going to listen to during a 2-day trial to help make up my mind with some definitive things here. But
Understood.
the fact, I mean, this case can have constant tit for tat and tit for tat and tit for tat. I'm sure there are things that I understand, well, she's not doing this and that. My question is, I need your client to understand and tell me today that he can follow the rules as they are today until they're looked at, until trial of the matter, or be prepared that if he doesn't, that he's not going to have visits between now and then, because I'm not going to litigate the matter until it's trial time.
The emergency request fails, but the court doesn't walk away quietly. Joint custody is ordered. No alcohol, no marijuana, mediation required. Child support effective November 1st. This is how judges balance rights with caution. No panic ruling, but structured safeguards. Both parents now operate under clear, enforceable boundaries moving forward.
Definitely.
And if he can do that, I just want to make sure he can, then we're going to keep the orders the same. And any of these other things that you want to bring up about what happened at Christmas, because you think it helps your case to show that the other parent is antagonizing, the other one is not co-parenting, does not support the relationship, et cetera, or is a risk to the child because they're going to circumvent a healthy environment for the child, or they're not willing to provide one because they have an alcohol abuse issue. I mean, whatever those arguments are going to be, you can take this stuff. Thankfully, you included it in your pretrial, which I appreciate, and I can hear it then. And I hope there's no termination of parenting time between now and then, or any unwillingness to exchange the child. Mr. Olson, I would highly recommend that your client get a call or an email to you and just get your approval to not follow the parenting plan. I think that protects her, and you as an officer of the court can tell me, I listened to the situation, I advised my client that I think the order triggers the termination of parenting time and that she was within her legal rights to do so.
Yes, ma'am.
I'm not ordering that today because we haven't had a hearing, so I'm not adding any new orders today. I'm not ordering that today, but I would strongly suggest that. And you can visit with her about that and advise her accordingly, however you want to. But that would be a suggestion that I'd make, and then we will really get to the bottom of all of this. Is there any chance? Let's see here. I just want to see. I did set a noon chiropractic appointment, but I can move that so that we can take advantage of noon hours if we need to. Yeah. That is really all I have is those 2 full days. So let me know if you have any concerns about that. I don't mind starting at 8:30. I don't mind going till 5:30 if we have to. And I don't mind taking a very short lunch hour. So if you'll need to let me know if you think that's gonna be necessary. Because the only thing I have is 2 hours Monday morning available between 9 and 11. And I doubt you guys have that available. And otherwise, I don't have anything available until March.
Your Honor, while we're discussing the trial, just as process, I guess, will Mr. Olson go first because it is his motion? We're kind of
Yes.
starting at square one, but I just wanted to clarify.
Yes.
Okay.
Yes.
I think we could try to be obvious, famous last words as well. But I think Mrs. Locke and I've had cases together. I think we will try not to get bogged down in minutia, Your Honor. And I always do anyway, but I'm sure Miss Locke and I can touch base before the 5th and try to get as many things stipulated to as possible so we don't have to go through all that and waste a bunch of time admitting exhibits. Not waste, but you know what I mean.
Okay.
To try to get it done in the 2 days for sure.
Okay. Yeah, that would be very helpful. And all I'm asking from you is to really organize your case. I will try not to interfere with I will try not to interfere with a lot of questions. I tend to do that, and I can contribute to slowing things down for sure, and I know that. I'm try not to do that at all. You guys are capable counsel. You'll get to it if you don't. But if you would be as organized as possible, what's important in your case, and be considerate of time. Let's do everything within our power to have this done within that 2 days. I don't think it helps. I don't think it'll be good for anybody to go beyond that. So please keep that in mind as you're preparing your questions or you're organizing your witnesses or getting ready for trial. And the more you can stipulate to and not argue about exhibits, or if if we can find time to do a pretrial hearing because you want to go over something. I don't know how much time you have available or we have available between then, but if there's something I can clear up for you, please let me know. Otherwise, we'll see you at trial.
No emergency found. Shared custody confirmed. Structured exchanges. Mediation mandated. The judge reinforces constitutional parenting rights while imposing strict conduct rules. This wasn't about winning, it was about stability for a 4-year-old. Custody battles aren't emotional contests, they're evidence contests. Like, comment, and subscribe for more shocking courtroom stories.